appeal in the matter of London Borough of Brent and Howe.
Yes, Mr. Calzavera. We've read the scouting arguments, we've read the district judge's judgment, and we've read the authority.
I'm grateful, my lord. Can I start by saying that we were told that we were welcome to sit in this bench. I'm not used to sitting in this bench. We mean no disrespect by it.
It's fine.
Grateful.
Means I can hear you better.
Grateful, my lord. I appear for the appellant local authority. My learned friend, Mr. O'Sullivan, appears for the respondent occupier. Yes. My lord has indicated that your lordships and my lady have had a chance to see the papers, so I won't go through the formality of ensuring you have them all. May I say that I intend to construct my submissions in 7 steps?
Yes.
First, the issue and outline. Second, the facts comprising the judgment. The 3rd to 6th parts of the statutory scheme. So the 3rd is to whom the right to buy belongs. The 4th is the 4 stages in the process. The 5th is how the right can be lost. The 6th is family members. My lord would have seen section 1, 2, 3. And the 7th, finally, my submissions. So starting with the issue and outline, the appeal gives rise to a short point of law. Does the secure tenant's family member obtain the right to buy by mere service of the RTB1, which is the section 122 claim form, or is his right obtained later, which I submit is when it is established? This court has previously held that once the family member's right has been established and all matters have been agreed between the tenant and the local authority, the fact of the later death of the tenant does not affect the family member's right. So I take that opportunity to say that the novelty in this appeal is that the secure tenant died a week after service of the RTB1, so that by the time the family member's right came to be established, 3 years later, there was no secure tenant in existence. That's the outline. Move on to the facts. I don't propose to go to any of these documents save for the judgment, but so that your lordships, my lady, had it in mind, the RTB1, which is on page 5 of the supplementary bundle, was served on the 18th of May 2020. The RTB2, which is the statutory form under section 124, was served on the 21st of May 2020. That's at supplementary bundle page 17. It admitted the tenant's right, but denied the family member, the son, the respondent's right. On the 25th of May, supplementary bundle page 19, the tenant died. This claim, the certified copy of her death is on page 19, my lady, of the supplementary bundle, 25th of May 2020. My lady's probably misled by a mistake I've made in my skeleton argument, and if so, I'm sorry. 19, my lady, supplementary bundle 19.
It's signed the 23rd of June.
The date and place of death is given as 25th of May 2020. Top of the form.
Yeah.
I don't need to... No, I'm sorry, my lady. I don't need to take you to the intervening facts. What then happened, and I don't need you to turn it up, but it's core bundle page 52, is that on the 23rd of November 21, the underlying claim under section 181 was brought. It sought 2 remedies. The first was a finding of fact that the respondent satisfied the residence requirement. We'll come on to what that means shortly. And the second was a declaration, and I'll read it, can therefore be added to that application under section 123 of the Housing Act 85 and continue that application as if it were his own application as joint tenant. That's the declaration that the respondent sought. The first page I do ask you to turn up is page 38 of the core bundle, which is the decision of the Deputy District Judge of the 20th of July 2023. My lord would have seen this, so I take you only to the passages that I say are pertinent. Could I ask the court to start with paragraph 10? Judge set out the second issue, whether if I find in Mr. Howe's favour on the factual issue, that gives me the right to declare that he has the right to buy under the statutory scheme. And then jumping over the factual findings in respect of which there is no challenge, at paragraph 35, at the top of page 44, the judge finds it is proved that Mr. Howe lived at, that should say 45, Saltcroft Close, for at least 1 year before his mother sought to exercise the right to buy on the 11th of May 2020.
It may not matter, Mr. Caldevar, and this is purely for my own interest, but is the address a flat or is it a house?
I understand it to be a house. That matters to the discount.
It does. It was just that at one point I think I picked up somebody said that the discount was 70%, and if it's a house it wouldn't be.
That's me, my lady. There's a very badly worded sentence. That's the maximum discount anyone can obtain, rather than the maximum discount that Mr. Howe could have obtained. So that passage in my skeleton argument should have said 60 to be relevant to the facts of this case. Then paragraph 42, please, on page 45. The key question the judge considered was whether, for the purposes of 1233, the mother had validly required her son to be added. In my view, the question of whether she had made a valid requirement is resolved by the factual findings I have made. She had validly required Mr. Howe to be permitted to share the right to buy with her because he, in fact, had been residing with her throughout the period of 12 months, ending at the date of the giving of notice. And then
Challenge that paragraph.
That paragraph is central to the judge's determination.
You say that's wrong.
I say that's wrong, yes. I say it's wrong that you answer the factual question and then don't consider separately the question of law. It seems to me, and I may be misreading her, that the judge is saying here that as soon as the residence requirement is satisfied, whenever the residence requirement is satisfied, it makes no odds what's happened since.
No, he's not saying that. What he's saying is...
My lord.
She, rather.
Yes.
Well, what she's saying is that if the notice validly required the sharing of the right to buy with the family member, then that family member is deemed to be a joint secure tenant. And the question whether the notice was valid as at the date the notice was given. If, therefore, the son satisfied the residence requirement at that time, then the notice did validly require the sharing of the right to buy. Ergo, he's entitled, because he's still living there, to proceed with the process. That's what she decided.
Yes, if there's a distinction, I'm sure there is, if there's a distinction between what my lord said and what I said, I prefer my lord's explanation. That is as I understand it, yes. Then it's paragraphs 47 to 49. To emphasise the point my lord has just put to me, the judge makes clear at 47 there is a deemed secure tenant. At paragraph 48, the judge considers Harrow and Tong and says that the distinction that I sought to draw between Mr. Howe's circumstances and Ms. Tong's circumstances would introduce a degree of arbitrariness such that it should be avoided. And then at paragraph 49, the judge reiterates that the judge makes clear that she is prepared to make the determination that the right belonged to Mr. Howe jointly with Miss Howe and he is to be treated as a secure tenant for the purposes of Part 5 of the Housing Act only. That's Part 2, facts. Part 3 is the start of my analysis, well, my exposition of what the statutory scheme provides. Could I ask the Lord to turn to page 4 of the Authorities Bundle? This is the Housing Act 1985, section 118. There are 3 categories of person who can exercise the right to buy. This is the first category of person in subsection 1. A sole secure tenant has the right to buy. The second category of person is in subsection 2. Joint secure tenants jointly have the right by statute. And the third category of person is on page 9, section 1, 2, 3. That's subsection 3. And I'm not going to try and hide from this section. I'm going to come back to this in substance. But for this part, I only want to look at 1, 2, 3, 3. The secure tenant can share the right to buy with an occupying family member. And as I say, I'm going to come back to this. There are 2 things I say for now. The first is that is the third category of person who can exercise the right to buy. And the second is the family member's right is not granted by statute per se. It is parasitic on the existence of a secure tenant with an exercisable right. Could we then turn to the decision in Thornley? For those with hard copies, it starts behind tab 4. For those without, it starts on page 39. And the judgment starts on page 41. Lord Justice Mann, in the first sidelined passage, third line of the first sidelined passage, the single question is whether the loss by a secure tenant of his status as such entitles the landlord to refuse to convey an estate in the dwelling house, even though all matters relating to the grant have been agreed between the parties. We'll come to see what all of those terms mean. The facts are in the second sidelined passage, starting at the top of the red line. The tenant claimed to exercise the right to buy. The landlord admitted the right.
And before there was a conveyance, the secured tenant lost their status by subletting.
I'm grateful, my lady. And as a result, the bottom of the sideline, it ceased to be and could no longer become a secure tenant. Proceedings for possession were brought over the page, and the defence is that the local authority became under a statutory duty, so that defeated the claim to possession.
Yeah.
The court at 43, and this is what I want Thornley for at the moment, this is the only authority I'll come to twice, identified 4 stages. The first is the claim to exercise. The second is the establishment of the right and the agreement or determination of the terms of the grant. Sorry, the third is the agreement or determination of the terms of the grant. And the fourth is the consummating stage, which is the grant. So if we can just translate that into the statutory scheme, starting on page 8. Which is section 122, subsection 1. Stage 1 is the claim to exercise by written notice. And so that we don't have to turn this section back up. Subsection 2 defines the relevant time as being the date on which the notice is served. Stage 2 starts on page 11 in section 125, and it comprises 2 alternatives that we see in subsection 1 in brackets, either by admission or otherwise. By admission is section 124. And we see at 124 subsection 2 that the landlord has, relevant to the facts of this case, 4 weeks in which to respond by written notice by RTB2. The otherwise part in section 125, what do I mean by that? The other way in which the right can be established.
Section 181, county court application.
Great for my lady. Section 181 on page 22. And what we see at section, I don't need anyone to turn it up. What we see at section 125 is that it is a particularly important section because without being established, the process goes no further. This is the gate between claiming the right and exercising the right. Stage 3 also starts with section 125(1), and there are the various other steps that go to the terms of the grant, principally the purchase price and the discount, that I don't need to take my lord, my lords, my lady to. And then finally, stage 4 is on page 17, page 17 at section 1381, where the right has been established and all matters have been agreed or determined. The council, well, it could be other landlords, the landlord is under a duty to, and for shorthand, convey, which is enforceable by injunction, as says subsection 3. We saw claim to exercise in section 125. For exercise, can we please turn to McKeown, which is behind tab 3, starting on page 29. And the material part starts at page 35. Sideline passage from G. The tenant submitted that having served the notice, she exercised the right once and for all, after which time the landlord became under a statutory obligation to convey the house. So, H, an order for possession made now would not be capable of depriving the statutory right, depriving the tenant of the statutory right. And over the page, on page 36, the passage starts at F. Counsel for the authority submitted the exercise of the right as a continuing process, beginning when the tenant serves the notice claiming to exercise and ending only when he finally pays the purchase price and takes his conveyance. On completion, and the conclusion in which we're interested in is again over the page 37 at G. The Act of 1980, and I understand there to be no dispute that the 85 Act being the consolidating act that drew these provisions in, this applies equally to the 85 Act, treats a tenant as purporting to exercise his right to buy at any time and from time to time when he takes steps towards implementation of that right, up to and including completion of the purchase. So, stage 1 is the claim to exercise, stages 2 to 4 are the exercise.
So this case establishes, does it, that if the tenant serves notice, or indeed at any stage up to the section 138 conveyance, it's still possible, because there's still a tenancy in place, for the landlord to serve notice of possession. And if he succeeds, then of course that defeats the right anyway, because you can't get the right to buy, you can't exercise it when there's a possession order in place.
That's what McKeown says.
Yes.
Dance, which I haven't put in the bundle because it's been overruled, then suggested that in fact there might be an equitable right earlier, and Lovell, which I did put in the authorities bundle, not because I want to take you to it, but because it makes it clear that Dance has been overruled Dance. So yes, my lady, that is the position. The history looks slightly different, but that is the position now. That's section 4 of my submission. Section 5 is how the right is excuse me, how the right is lost. I'm not going to take you to, but I'm just going to give you the following ways in which it can be lost, and then I'll take you to the one that actually matters. Section 121, which is the provision to which my lady just referred as to a possession order being made. Section 1223, which you have withdrawal. Section 125D and 125E, which both deem a withdrawal. Section 138B, which is about demolition, and section 141, which is another deemed withdrawal. They're not material, but if I'm going to give you the statutory scheme, I want to give it to you in full. In this case, what we're interested in is the principal qualification for claiming and exercising the right. It belongs by statute, as we saw in section 118, to the secure tenant only, so that if there is, by statute, no secure tenant, there is no right. And the case that first dealt with that is Swan, which is behind tab 2, starting on page 23.
That was under the old Housing Act, but it's been approved in ton
Great for my lady. Yes.
expressly, so ton is really the case we want, isn't it?
Tongue is the yes, my lady. Can I take my lady to Swan? Tongue is the case I want, and indeed the case my learned friend wants. But can I take the court to Swan first? And I'll do it briefly with that indication well in mind. Page 25, second paragraph of the judgment of Lord Justice Ackner. Claim is made. Fourth paragraph, it's admitted. Mrs. Swan leaves, nothing turns on that. And then the last of the sideline passages, Mr. Swan receives a letter saying you can buy it either in circumstances A or in circumstances B. Which one do you want? And over the page, the judge decides that he never responds. And also, on the balance of probabilities, balance of probabilities never responds, did not take the matter further. And then at the bottom of that page, the judge also finds that by the 1st of April 1983, which is sometime after the claim was made, the right was admitted, and the stage 3 letter offering terms was sent.
Yeah, so he moves out, basically.
He moves out.
Goes to live somewhere else.
Goes to live somewhere else. He's not occupying the property as his only or principal home. Over the page 27, he defended the claim on the basis that he was entitled to buy because his right had previously been established. And the judgment, the ratio that I want is on page 28, which...
Yeah, it's the last couple of sentences.
Yes. And just to note while we're there that Thornley at 96, which I need to come back to in a minute, says that isn't obiter.
Sorry, page 96 says...
I'm going to take my lord to Thornley now. I said it was the one decision I was going to come to twice. I'm sorry for doing that. But if my lord could turn to page 45...
It doesn't matter whether Thornley says it isn't obiter, because it's been expressly approved by this court in ton.
I'm grateful, my lady.
The principle is well established, Mr. Puzzler.
I'm grateful, my lady. In that case, we can go over 45 and 46. Could we look in Thornley, please, at the argument at 47, top of the page. Mr. Terry, for the tenant, said that the status of secure tenant had to exist at the time of the claim and of admission, but its loss thereafter was irrelevant, save that it exposed the tenant to the risk of possession. And the conclusion is the bottom of the sidelined passages. Tenant who has ceased to be secure has no right to enforce under 1383. And as my lady says, that's, I'm pushing an open door on this. The conclusion accords with my belief that most people would find it surprising if Parliament had enacted right to buy provisions which enable the person to acquire a house at a discount when he no longer occupied it as his only or principal home. And then Lord Justice Glidewell, who's not in the majority, at page 48, at the sidelined passage, says broadly the same thing. What I say, and I know that my lady has the point, so I'm sorry for repeating it, but I just want to underline it, is that the existence of the secure tenant is crucial.
Yeah.
My lord has it. I'm grateful. That then leads to the final part before we get to the substantive submissions, which is the family member, and that is in section 123 on page 9 of the authorities bundle. What I hope to do is go through the section and then make my submissions on it in submissions. I hope that proves satisfactory. I understand it might not, but let's see how we get on. Subsection 1, there must be a secure tenant and an occupying non-tenant family member. Jumping to subsection 2 before I jump back to subsection 1, to validly do anything in respect of the occupying non-tenant family member, that person has to have been residing with the tenant throughout the period of 12 months, ending with the giving of the notice. And I flag those words because that's the same wording, or substantively the same wording, as what the relevant time means in section 122.
Well, is it? I mean, nothing turns on it in this case, but the giving of the notice isn't the same as the receipt of it, and the relevant time is from the date of service.
Oh, I'm grateful, my lady. That is an important distinction that I hadn't appreciated. Yes.
But in this particular case, it doesn't matter a ha'porth of tar because Mr. Howe was living there throughout.
Yes.
But there might be cases in which it did matter.
And then looking at 2A, the spouse or civil partner appears not to have been residing. It's enough. It appears that the spouse or civil partner have to have been occupying, but they don't have to have been residing 12 months ending with the giving of notice. And then going back to subsection 1, the tenant may, in her notice, require that her family member should share the right to buy with her. She can't give it to him. She does not create a freestanding right. She shares it, and his right is parasitic on hers. Subsection 3, where by such notice family members are validly required, and validly requires just tells us that we have to reread subsections 1 and 2, to share the right. There are the two consequences that Tong identifies. First, the right to buy belongs to the secure tenant and family member jointly. And second, they are treated for the purposes of Part 5, not Part 4. Part 4 is about security of tenure proper, as joint tenants. That, I hope, is a helpful summary of the law.
And that brings you back, doesn't it, into section 1182.
Yes, jointly must mean jointly. Yes, my lord. That brings me to the final part, longer, more substantive part of my submissions, which is my submissions. As I've said, and I hope I have summarised it appropriately in my skeleton argument, the question in this appeal is whether the family member obtains the right upon service of the RTB1, or whether it is obtained at some later point, which I have said is when it is established. My lord has, in the first part of my submissions, said in much better terms than I have what the judge found. My shorthand, and I hope it encapsulates it, is that whenever the residence requirement is found to have been satisfied, the magic, if I can put it that way, is in the RTB1 itself. And the consequence is it makes no odds what has happened to the secure tenant. There are 5 propositions by which I hope to establish that there must be a real-world secure tenant until the family member's right is established. And if we could start with page 9 of the authorities bundle. In my submission, section 1233 does not answer the question in this appeal. I accept that it is in the tenant's gift to share the right to buy, by her RTB1, but in my submission, that merely answers the question by which document the right is shared. It makes it clear, for example, that nobody is looking at the list of family members on the tenancy agreement or any correspondence passing between the parties. It does not, in my submission, answer the temporal question. The only temporal passage relating to the residence requirement itself, the only temporal submission relates to the residence requirement itself in subsection 1232A, but in my submission, the fact that it's expressed in the present perfect does not mean that the entire section is backward looking, and I find support for that proposition in Tom, which we'll come to shortly. I note my lady's response to that. I'll foreshadow what Tom says by saying that the court, I think it's Lord Justice Norse, held in that case that occupy has to be read in the present tense at all times throughout the process. And in my submission, that tells us that one is not only looking, as I said a moment ago, in the present perfect. Had the draftsman wanted to fix the consequences in subsection 3 with effect from the relevant time, or as my lady has rightly said, with effect from the giving of notice, he could have said so anywhere after the comma in subsection 3, thereby making it clear that it was irrelevant when the right was established. But he didn't do that.
I'm afraid I just don't follow the argument. It's my fault, I just don't understand it at the moment, Mr. Calzavaro. You'll have to go a little bit more slowly. Why do you say that subsection 2A does not require it to be established at any time as a matter of fact that the person concerned has been residing with the tenant at the time of the giving of the notice? I
don't say that, my lady. I'm content that the question of fact is frozen at the time of the giving of the notice.
All right, so if a notice is then given, the tenant has validly required that person to share the right to buy with her. Yes?
Yes.
Right. If they have validly required that person to share the right to buy with them, then subsection 3 says the right to buy belongs to the tenant and those members jointly. And it must be at that moment, not some moment in the future.
That's my learned friend's case. That's what the judge found, and that's what I have
That's what Tom found as well.
Well, I hope to show that that's not what Tom found in a moment. And again, that's what my learned friend found his case on, and what the judge agreed with.
Yes.
But
look, I'm just trying to understand your argument
Yes.
at the moment. So you say the tenant, the statutory tenant has validly required a family member to share the right to buy.
Yes.
So far, so good.
Yes.
But you say that that right doesn't kick in until some later date.
Yes, that's my submission, my lady.
And how do you construct that out of subsection 3, just so I understand the argument?
So there are two parts to my submission, and I understand. I'm here because it didn't find favour below. I understand that it might not find favour with my lady, but this is my submission.
I simply want to understand it.
Yes. My submission is in two parts. The first part is that by such a notice answers the factual question of the valid requirement, but it doesn't answer, and I say this is contained in the bit after the comma in subsection.
Sorry, just say that again. By such a notice satisfies what?
The question my lady just put to me, which is what I've been trying to say back to her in much more ineloquent terms than she put to me, is that the notice validly required the tenant to share the right to buy. I understand that the residence requirement had to be satisfied on the date of the notice.
Yeah.
But my submission relates to the second part of subsection 3. The draftsman didn't say when the right to buy belongs, present tense, to the family members jointly, nor when they shall, present tense, be treated for the purposes of the part as joint tenants. It doesn't seem to me that I can take it further than to say that this subsection doesn't answer the question.
Right.
My submission is not that this subsection makes it clear that the time at which it must be determined, that which at time at which it is
I
established.
think I now understand the argument. So what you say is, although there is a valid requirement to share the right to buy, the draftsman does not spell out at what point that right to buy belongs to the tenant and the members jointly, and at what point they shall be treated as joint tenants. It leaves a gap. That's the argument.
That's all I want. I want that gap.
Right.
Because if I'm wrong on that gap, I have no, I lose.
Yes.
I need the door to be ajar,
Yeah.
so that I can make my subsequent submissions, which I hope.
Right. So it begs the question. Now I understand your argument. Sorry, I'm being very slow. So the draftsman doesn't say when it belongs or shall. Yeah. Okay. Treated as, yeah.
The second proposition is a response to my friend's case, and can I ask the court to turn, please, to Francis, which is behind tab 8. The judgment of Lord Justice Carnwath starts on page 82.
Yeah.
Those in this court who have been doing this considerably longer than I have will remember that the facts of this case occurred before the Act was amended to overcome the problem of tolerated trespassers, which is why there's quite a strange factual background. Factual background starts in paragraph 3. The tenant submitted a right to buy application in respect of, there are 2 properties. Property 1, the council denied the right. Paragraph 4, the tenant applied, as I understand it, he made 2 applications in the possession proceedings. The first was for the revival of a secure tenancy. Now that's why I mentioned the tolerated trespasser point. That's to bring the secure tenancy back into existence, because at the time of these factual circumstances, the possession order per se, with a trigger, destroyed the tenancy rather than the tenancy being destroyed when the possession order was enforced, which is the current provision. So as was, you were no longer a secure tenant because the possession order was made. So he applies for the revival of his secure tenancy and for an order that he had been a secure tenant from the 1st of September 1999 onwards. Now, it's not clear to me whether that order that he sought was an order under section 181, or whether it was just an order with retrospective effect in relation to his existence as a secure tenant. But I think it's the latter.
Well, that used to be the position, wasn't it? That was sort of Brent and Boroughs and all that, that if you got your tenancy reinstated, it was retrospectively reinstated.
That's why I make that submission, my lord. But it's not clear from the judge. Can I say I think? I think that's right, my lord. It's certainly right about Borough's case, but I think that's the right construction of the facts of this case. That was then refused by the district judge over the page, still in paragraph 4. So the district judge said, I am not reinstating your tenancy with retrospective effect. Paragraph 5, he moved out of property 1, and he made, incidentally, an application for the right to buy property 2, which never proceeded to completion. Paragraph 6, on appeal, after he's moved out, the circuit judge declares that Mr. Francis had indeed been a secure tenant of property 1 throughout the relevant period. That's the declaration. There's no indication that the court made any declaration in respect of the right to buy.
He's lost it anyway because he's moved out.
He's moved out and it's been destroyed. I think by then it had been demolished. Destroyed was probably the wrong word made. It's been demolished. Paragraph 7, the local authority brings a possession claim in respect of property 2. Mr. Francis counterclaims for damages for breach of statutory duty, and this is important, the wording is important, for the previous failure by the council to grant him the right to buy. And the way in which he puts his case is at paragraph 17, at page 85. Mr. Collard, for the tenant, said there were 2, over the page 86, relevant duties. An implied strict duty to permit him to purchase the property if he was entitled, and a strict implied duty, I don't know why the words are reversed, anyway, to get the answer right as to whether the tenant is or is not entitled under the right to buy scheme. That's what Lord Justice Carnworth, indeed the court, was dealing with, and his lordship's judgment, sorry, this isn't sidelined, his lordship's conclusion is at paragraph 22 at H. Section 118 does not impose any duty. It merely states the right, and the right is to be established by the procedures under the Act.
Your page, paragraph 22.
Sorry, my lord, paragraph 22, H.
Yeah.
Section 118 as
No, I
such.
see. Yes.
Sorry, my lord.
There's no statutory duty, there's simply a statement of the right which you have to use the statutory process to enforce.
Indeed. And then Lord Justice Lloyd, who is also in the majority, says the bit at D, the landlord's notice denying the right does not affect the right in any way. My learned friend relies on that. I take no issue with it. The court was not concerned with family members. It did not consider the question in this appeal, and nor am I hurt by Lord Justice Lloyd's remarks. I'm not suggesting that the RTB2 affects the secure tenant's right. I'm not suggesting it affects the family member's right. My submission relates to timing, not to what the authority did.
But in an indirect way, you are suggesting that the RTB2 affects it, because you're saying it's basically in the gift of the council to decide whether or not to accept the statutory family member's right. So if the landlord says, well, I'm satisfied that you have the right to buy, and they do it at the same time as the tenant, then everything in the garden is rosy. But if for any reason the council decides that it's not satisfied with the evidence, or it requires somebody to prove, then on your analysis, it's too bad. If the tenant then dies, that's just tough.
I can't shy away from that, my lady,
No.
yes, but it's the establishment that matters,
Yeah.
not the RTB2 per se. That's the distinction between my case and what my learned friend
Well,
seeks to impose.
I think
upon.
you say it can be established by the RTB2 if the local authority admits the right. Otherwise, it has to be established by the court.
Yes, my lord, precisely. That's my second submission. My third submission is this. It is integral in the statutory scheme that there is a secure tenant at all times until completion. And we're going to Tom in a minute, but the secure tenant has the right by statute 118. The secure tenant claims to exercise the right 122. The secure tenant can share the right 123. The secure tenant is the person to whom the grant is made 138. And if there is no secure tenant at any time, there is no right. Swan, Thornley, Tom.
Yeah.
Fourth, the family member's right is parasitic on the existence of a secure tenant with an exercisable right. There are, in my submission, two key ways in which that is clear. The first is in section 1231, where we see the secure tenant can share her right with him. She can't give it to him. He can't obtain it in any other way. He needs her. And the second is by a section we didn't look at in our trawl of the statutory scheme, but to which I invite you to turn now, which is page 15, section 136. Can I just make this clear? This isn't the answer. There's no smoking gun. The submission I'm trying to make is that the secure tenant is so integral, is so vital, is so central to the process that given that I have, I hope, been able to open the door, this court should find that the secure tenant matters enough that establishing it while she still exists is of importance. Subsection 1, where after the secure tenant has given notice, another person becomes the secure tenant under the same tenancy. I need to define that. That means succession, or it means a section 91, not 92 because of the terms of the subsection itself, assignment. That's a family order. So where a new person becomes the secure tenant by way of succession or a section 91 assignment, the new tenant is in the same position as if the notice had been given by him. So the the dead or departed the dead or departed tenant's right and concomitant discount and valuation date applies to the new tenant. And why do I want this section? Subsection 6 over the page. The preceding provisions of this section do not confer any right on a person required in pursuance of section 123 to share the right to buy, unless he could, let's just pause there for a moment. No, let's read it all. Unless he could have been validly so required had the notice claiming to exercise the right to buy been given by the new tenant. What does this say? That the existence of the secure tenant is so integral to the family member's rights that even if the parties are at stage 4, the arrival of a new secure tenant destroys the family member's right unless he can parasitically attach himself to the new secure tenant. And I say again, that means the family member is tied to the secure tenant. He needs her.
I'm not quite sure that is right. Let's have a look at subsection 6. The preceding provisions, that is the succession provisions, so new tenant comes in. Those provisions don't confer any right on a person required in pursuance of section 123 to share the right to buy. Person required. Who is the person required in pursuance of section 123 there?
The family member.
Why? Don't confer any right on a person required to share the right to buy.
I'm sorry, Melody.
The person who's required in pursuance of section 123 to share the right to buy is the landlord, isn't it?
For the outgoing tenant.
Or the outgoing tenant.
The person in this case who required the right to buy to be shared was Mrs. Howe.
But that, sorry, my lord, that would mean do not confer any right on a person who required. I understand the person required to be the family member.
How can it be? The person required to share the right to buy is not the family member. He's the beneficiary of the requirement. The person required to share the right to buy is the landlord.
That's not how I read it, my lady.
He's the person to whom the request is made. The right to buy is requested by the outgoing tenant, right, the secure tenant. That's the person who makes the request. I can't see how the family member could be the person who is required to share the right to buy.
So just so that I understand, my lady's construction is that who? The landlord or the secure tenant?
I read it as the landlord because the only person who could be required in pursuance of section 123 to share the right to buy is the landlord.
So if it's the...
He's the person who is giving the right to buy to the tenant, if you like, and the request is made of him. So a person who is required to share has got to be the landlord.
My lady,
It may not be what Parliament intended. It may well be, my lord is right, that it was intended to be the outgoing tenant, the person who makes the requirement, but that's not how it reads.
can I say what the encyclopedia says, and then
Yes.
say what my response is, my lady, to that question? The encyclopedia, I'm sorry it's not here, says 4 lines. There must also be a reassessment of qualification of any added purchases, which I understand means that the editors think my construction is right.
Must also be.
Let me read it again, my lady. There must also be a reassessment of the qualification of any added purchases. Sorry, my lords, my lady, you can't see this. The title is subsection 6, and then there is the relevant passage, and I'm reading under the title subsection 6, so that my lord knows that this is relating to the provision we're looking at. The new secure tenant will usually be amongst those who might, in any event, have been added by the former secure tenant, but it does not follow that those who qualified in relation to the former secure tenant will also qualify in relation to the new. So I might be wrong and the editors might be wrong, but the editors of the Housing Encyclopedia think that my reading is correct,
to your reading and spell it out again, please, in words of one syllable, so I get it.
Yes, the proceeding.
Say the preceding provisions of this section don't confer any right on the the family member.
Yes.
Yes. To share the right to buy.
I think, my lady, if you're adding the words "the family member," you can just delete. You can delete all the words to the comma. The preceding provisions of this section do not confer any right on the family member, comma, unless he could. That's my construction.
Right, so the preceding provisions of this section don't confer a right on a person who's already got a right, unless he could have been validly so required.
Can we do
that makes no sense to me at all.
Can we do an example, my lady? Husband and wife are tenants. Husband dies, wife succeeds. That follows by statute.
Yeah.
The son, in the meantime, the son earlier on was attached to a right to buy application
By the husband.
by whomever. The succession means, in that case, that because he is still a family member, because he is still entitled to share the right to buy by way of qualification, he continues to share it. A different example. It can be a non-family member who succeeds. That's section 86A2, because the tenancy agreement can say you can allow anyone to succeed. It's unlikely, but it can, in principle, say anyone can succeed. So let's imagine a case in which it passes to a friend of whom the son is not related, is not a family member. In that case, the family member who had the right has his right washed away. As to why it can't be the landlord, the landlord isn't sharing anything with anyone.
No, well, that's what.
So it can't be the landlord.
I'm still struggling with person required to share the right to buy, meaning the person who actually gets the right to buy.
Section 1233 says any members of the tenant's family are validly required. On my reading, the draftsman's language and use of tense follows through. It's the family member who is validly required to share the right to buy in 1233, and it's the family member who is the person required to share the right to buy.
But your essential point, I think, is that if the validity or otherwise of the notice under section 123 is to be determined as at the date of the notice, you would have thought that by virtue of the deeming provision, the family member is deemed to be the joint secure tenant with the tenant exercising or serving the RTB1. But if that is the case, then section 1366 makes very little sense, because once the notice has been given and is established, what, you ask rhetorically, is there to deprive the family member of the right to buy? And section 1366 plainly envisages that that family member can be deprived of the right to buy by subsequent events.
Much more eloquently than I would have been able, my lord, yes. Yes.
And whereabouts do we find that addressed in your skeleton argument?
There is, I say candidly, no reference to section 136 in my skeleton argument. Indeed, my learned friend was kind enough to allow me to add section 136 to the bundle in those circumstances. It is not there, my lady.
Yeah.
My fifth submission, my fifth proposition, is that the judge, I don't need to take my lord to it unless it would be helpful. At paragraph 48, I took my lord earlier to the suggestion that there would be such a degree of arbitrariness that the court should construe against my construction. My fifth proposition is that the judge was wrong to suggest that it would be arbitrary to require that there remains a secure tenant in existence until the family member's right has been established. In my submission, that fits coherently within the scheme for two reasons. First, it's the dividing line between a claim to exercise and the exercise of the right to buy, where the exercise follows establishment and encompasses all of the substantive stages up to sale, which we saw in McKeown and then in Thornley. The second, and my lady put this to me much earlier, and I'm sorry only to come to it now, is Tong. Tab 5, the judgment starts on page 550, and I'd like to start on page 51. Top of the page. Sorry if I take this more slowly, but this is the case on which my learned friend founds his case, and I know that my lady has expressed some disquiet as to how it resolves, if I may put it that way, my submissions. Top paragraph, Tong Senior, I'm going to call her that if I may, claimed the right to buy and required that Tong Junior share it. The local authority admitted the right, that's the end of that first substantive paragraph. And then if I could just ask you to note this date. By the 6th of June 1989, all matters relating to the grant and the amount to be left outstanding had been agreed or determined. Stage 4. Next substantive paragraph, a year and a half later, Tong Senior died intestate. The local authority, 2 lines, this is the 4th line of that paragraph, thought and have throughout contended that meant Tong Junior, not being herself a secure tenant, no longer had any right to buy the house. Over the page on page 52, the first substantive paragraph, it's established that there must be a secure tenant until the moment of completion. If that were not so, the right to buy could be enforced by someone who had ceased to occupy the property as his only or principal home.
That's the endorsement of Swan that I was referring to.
Yes, my lady. And Jennings, which I haven't put before you because it seemed to me that it said the same thing. Mr. Denahan for the occupier, so for Tong Junior, referred to Dance, which has been overruled, and argued that the Tongs became jointly entitled to the equitable interest in the house on that date I noted a moment ago, on the stage 4 day. Lord Justice Norse, in the paragraph that starts in the circumstances, makes it clear that that argument can't succeed. You don't have it, so I'll just tell you that it was Lord Justice Norse who gave the principal substantive judgment in Dance. And then over the page, there's a paragraph that starts, Mr. McCarthy, it's the second paragraph. Mr. McCarthy appeared for the council, submitted that the right belonged to Tong Junior and Senior jointly, together, and not to one of them alone. And then Lord Justice Norse starts to give his judgment. If the subsection had ended with the word jointly, there'd have been force in that submission. But there are deeming words. It is a provision which tells us not only what is to be deemed for, but for what purpose. What was to be deemed here was that the Tongs were joint tenants. It's clear from the words of subsections 1 and 3 that a secure tenant, they're deemed to be joint secure tenants. Indeed, as Mr. Denahan pointed out, it's difficult to see how someone who satisfied the tenant condition in section 81 could become a joint tenant with a secure tenant without herself becoming a secure tenant. It's a sort of difficult passage to understand because the family member isn't the one who satisfies the tenant condition in section 81, it's the tenant. So the rejection of the council's argument arises because the Tongs were deemed to be joint secure tenants. The consequence, this is the paragraph that starts, then we must. what was the effect of that in the fourth line? Mr. McCarthy for the council accepts correctly that if the Tongs had been joint secure tenants in the real world, Tong Jr. would by her survivorship have become the sole secure tenant at the time of her mother's death. So the effect of subsection 3 is that Tong Jr. is deemed to have been the sole secure tenant for the purposes of section 138 from that date. And then this passage I promised my lady I'd come back to in the next paragraph. On this short ground, Tong Jr. is entitled to succeed. I emphasise that we are dealing only with a case where the deemed secure tenant still occupies the house as her only or principal home. It is, I think, implicit in section 1231. His lordship doesn't say it's implicit in section 1381. His lordship goes back to the very provision by which the family member's right is afforded. That state of affairs must continue up to the moment of completion. And if I may respectfully expand upon the point that was put to me by my Lord Justice Lewison a moment ago, that is another indication of the import of the facts as they exist through time, and not just the use of the present perfect in has been residing.
So, you know, what that's saying, translated to our case, I think, is that if Mr. Howe had moved out, then the right to buy would no longer be exercised.
Yes, that's the explicit consequence. The consequence I'm seeking to
Decided in the Thorn bit as well. So
the consequence I'm seeking to draw is I want an implication rather than what the ratio says. The implication I want is that you look at the present tense as well as the present perfect, and the consequence is that time isn't frozen with the RTB1. It's not enough to say the residence requirement was satisfied, ergo it doesn't matter what has happened by the time of the establishment of the right, because this court has said that you must continue to look at occupation, present tense, for 123, not for 138.
that's because you're looking at the secure tenant, and that's the only secure tenant that's left, and so that person's got to stay in occupation. But I don't see that gets you anywhere in terms of the point that you're trying to make, which is that you need to establish, which is an earlier stage. This is a future stage. This is a stage after it is that there is the deemed joint tenancy, and you're trying to persuade us that the deemed joint tenancy springs into effect at a later stage than the service of the notice under 1233.
My lady, I emphasise the reference in that paragraph to section 1231. The court did not say that there has to be, that state of affairs must continue up to the moment of completion for the purposes of 138, which is the provision containing...
But wait a minute, this goes in stages, doesn't it? If we look at the second sidelined paragraph on
Yes.
page 103, starting Mr. McCarthy submits, Lord Justice Norse tells us the words are a deeming provision which tells us not only what is to be deemed, but for what purpose. What was to be deemed here was that Mrs. Tong and Miss Tong were joint tenants. So that's the first stage of the deeming. It's a deemed joint tenancy.
Yes.
And then we get on to the next paragraph where he says they're deemed to be joint tenants for the purposes of Part 5. And then he refers to Mrs. Tong's death. And the effect of section 1233 is that Miss Tong is deemed now to have been the sole secure tenant.
Yes.
So the deeming here, you start with a deemed joint tenancy.
Yes.
The original secure tenant dies, and you're left with a deemed sole tenancy.
Yes. It doesn't answer the temporal question, my lord. It doesn't say when the deeming happened.
Well, the deeming on Mrs. Tong's death happened at the date of her death.
The second, there are two deemings, as my lord has said. The first deeming is Tong Jr. becoming the deemed joint secure tenant.
With her mother, yeah.
With her mother. The second deeming is Tong Jr. becoming the sole secure tenant by survivorship.
Yes.
The case of Tong does not answer the question when the first deeming happened.
I follow.
That's your submission.
That's my submission. The tenant's submission.
It's pretty claim, but it does, in fact, because the whole of that passage, from start to finish, is talking about the impact of the section 1233 notice. And it doesn't make sense, with respect, to read it in any other way.
I've two responses, if I may, my lady. The first is that the tenant in that case, the argument by the tenant, which was not accepted, although the tenant was successful, in that case, was that the material date was the 6th of June 1989, which was the date by which the right had been established and everything had been agreed. So the argument advanced in that case was not the RTB1, or it didn't, because it didn't have to be, or the date of establishment.
Where do we see that the 9th of June was the date that was required? Because if one actually looks at the fact that there was the admission of the right to buy, it's simply recited as part of the history. There's no way that it sort of comes to the fore in the analysis at all.
Paragraph 52, no, it's not in the analysis, it's the submission. At page 52,
Yes.
Just under the sidelined passage, there's a reference to dance, and then it says, has argued, in the circumstances I have stated, that the Tongs became jointly entitled to the equitable interest in the house on, and then the date it gives is the date on which...
But that's a different argument. That was a completely different argument.
That's to do with the equitable interest.
Yes, the argument that's not, the argument, as I said a moment ago, the argument that was not successful. All I'm saying is that in that case, the argument that was advanced
Right.
neither the argument advanced nor the conclusion answered the question from what date it was deemed.
No.
That's my first submission on
All
Tom.
right.
My second submission on Tom is that in the passage on page 53 at the bottom of the red sidelined section, Lord Justice Norse says, we're dealing with a case only where the deemed secure tenant still occupies. It is, I think, implicit in section 1231 that that state of affairs must continue up to the moment of completion. Lord Justice North did not say it is implicit in section 138, which is the duty to convey, that there must be a secure tenant at all stages up to conclusion. Lord Justice North said it is implicit in 1231. That is the provision whereby the tenant may, in her notice, require that not more than 3 members of her family who are not joint tenants but occupy the dwelling house as their principal home should share the right to buy with him. Lord Justice North was not saying that the reason that that state of affairs must continue is that that is the only person to whom there is a duty to convey. He was looking at the establishment of the right per se. He was looking at 123, which is not about conveyance, it's about the notice.
Isn't he simply saying that the 1231 gives somebody a right that they wouldn't otherwise have, and that is implicit in that they must remain in possession throughout if they're going to exercise that right?
My lady, if that were all it was, Lord Justice North would have referred to 1381. I'm repeating myself, and I don't think my submission is being improved by that. That's my submission, my lady. Sorry, I don't know if I've made this point, which I hope is important. Even if I'm wrong in my reading of that passage at page 53 of Tong, it indicates that one is not frozen with the present perfect. Maybe I did say this. One is not frozen with the present perfect in 1232A, and it indicates that the use of the present tense throughout 123 is not necessarily directed to the present tense as at the time of the service of the notice or the giving of the notice, because Lord Justice Norse was content to direct that the occupy in subsection 1 was present occupy rather than at the time of the giving.
Yes.
And then I say, finally on Tom, that it says nothing about a case in which there is no real world, my lord, I'm sorry, I've already said this, no real world secure tenant at the time it's established. Those are my 5 propositions. I have endeavoured to come up with examples which I say indicate that my learned friend's analysis is wrong and mine is right. I'm going to try them on my lord. Maybe they elucidate.
Well, we've read them, so...
I'm sorry, I've got 2 examples that aren't in my...
Oh, all right.
The examples
yes,
in my
that's
skeleton
fine.
argument...
Yeah, fine.
So the alternative argument is that as long as there is a secure tenant in existence at the time of the giving of the RTB1, it doesn't matter what happens to her after that point. My 2 examples are these. Example 1, the secure tenant claims to exercise the right and requires that her family member shares it. The authority denies the family member's claim. By the time the family member's claim is heard by the county court, the tenant has sublet the property. And in my example, I wavered on this. In my example, she sublet the property to him.
To whom?
To him, the family member. Because I think I need to face the point I've just been relying on in Tong, which is that it has to continue to be the family member's only or principal home, which is why I want in my example the family member to be the sublessee. He's still occupying it as his only or principal home, but she has sublet it. The consequence of her subletting it in section 93 is that security of tenure for part 4 is irrevocably lost.
Yes, both by the original tenant and the family member. They both lose it. And the family member is now occupying in right of a different tenancy, which was not, where the landlord condition is not satisfied, therefore it's not a secure tenancy.
The strange thing about section 1233 is that the family member is deemed to be a secure tenant for the purpose of part 5.
Well, occupying in right of that tenancy.
Yeah. I think your better example, if I may say so, is the one with the original secure tenant up sticks and leaves. That's the one that really starkly highlights the problem.
I hear the objections to my example. As I said, the problem with hypotheticals is that one never really knows how they'll play out.
But I think if you're sort of looking starkly at this is all desperately unfair and Parliament can't have intended these consequences, the simplest example is the one you originally gave us, which is the one in your skeleton argument.
I'm grateful, my lady. You have that example. I don't think it's going to help you. The point I wanted to make that my lord has, my lady's indicated, my lady has, is that if the magic's in the RTB1, the fact that the secure tenant for part 4, the secure tenancy for part 4 has been irrevocably destroyed, would give rise to a very strange outcome if in any event there remained a secure tenancy for part 5, but as my lord has put to me, occupation under a different tenancy. My second example, which may or may not be better or helpful, is I highlighted before that in 1232A, you can be an occupying spouse who does not satisfy the residence requirement. It doesn't matter. You just have to be there. So this is my example, which I hope helps. The secure tenant claims to exercise the right to buy and requires her spouse shares it. The authority denies the spouse's right. By the time the spouse's claim is heard, the tenant and the spouse have divorced. If the magic is in the RTB1, the ex-spouse is entitled to his declaration, even though he now no longer qualifies, even if the tenant no longer wants to share the right with him. And I wanted to say, my note says, and even if the tenant has determined her tenancy, but I'm sure my lord would say that similar provisions would apply in respect of that. But if I just use those first 2 ex hypothesi, in my submission, again, it cannot have been Parliament's intention that the ex-spouse should in those circumstances be entitled to a declaration that he has the right to buy, merely because at the time he had it. If that example is helpful, I'm pleased. So my submission in a nutshell is this, that the section 123 and specifically subsection 3 holds the door open. The authorities dealing with, in particular, section 123, including as it was in the 1980 Act, but also with section 138, do not answer the question arising on the facts of this case. And on the facts of this case, and indeed generally, you should, in my respectful submission, be satisfied that the import of the secure tenant is such that it would be wrong to ignore what happens to her after the RTB1 is given, and the moment in time that I have alighted upon, and I may have alighted upon a moment of time that is too early, but that is my case, is the establishment of the right.
Yeah.
Unless I can assist, my lord, my lords, my lady, those are my submissions.
So let me just understand your argument of construction, because this is all about 1, 2, 3, 3, isn't it? You say it has a gap in it. You've got to fill that gap somehow. And you fill that gap, how do you? By saying that, by reading it, whereby such a notice any member of the tenant's family have been established to be validly required to share the right to buy, then those members and they shall be treated from that time of establishment as being joint tenants.
I hope, my lord, to put the, well, I hope not to have to imply words, but I understand that I do have to imply them in the sense that you need to know how I read the section. So my first answer is that I don't want you to add any words into this. I'm not asking you to imply words into the statute. But my second answer is that I don't want to do damage at all to the first clause of subsection 3. I am content that one is validly required to share the right to buy by looking historically. It's the second clause. If I had to imply words to get the construction I want, I would say, from the relevant time, the right to buy belongs to the tenant and those jointly, and he and they shall be treated for the purposes as part of joint tenants.
And where do you find the relevant time?
The relevant time is in 122, and I do say it would be appropriate for it to be the relevant time rather than ending with the giving of notice, because what the draftsman is doing is...
The relevant time is the time when the notice is served.
Yes? Sorry, Melody, I think I've been unclear. That is what I want the draftsman to have said in order that I'm wrong. What I want the
Oh, I
draftsman...
see, sorry.
Yeah, sorry, Melody, I just heard myself and I understand why that was confusing. What I want the draftsman to have said in order that my argument is right is from the time at which the right is established.
Yes.
Sorry, my lord, that was a very... I'm sorry for the...
That's what I understand.
Incoherent answer. Is that all I can assist with?
Thank you very
I'm
much.
good.
We'll just retire for a few minutes.
Court rise if able. Could I please remind the courtroom that the live stream is still running? Thank you.
Thanks. Hi, Stephen, how are you? You could have told me I couldn't play in a case, but not read a statute. Yeah, but that's the answer to the whole case, isn't it? It's always the answer. Except that the tenant moves out, you're redeemed to your tenant. Is the court really going to make a possession? Yeah, the strange thing about this case is that I possession blaming history. And I had turned it down. My own application was I had nothing to do with it. I wasn't told about that until it happened. How did you find this? Okay, it's a bit more sense now. Obviously, that was my. I mean, if I was not construction, I don't see what the interesting point is. The Supreme Court's interesting in as well as complications in your side. This is the only case that will decide this point. Yeah. It's not an addition, it's withdrawn. Does it both? We had an employment before. What? Since
All rise if able.
Mr. O'Sullivan, the only point we'd like to hear you on is what you say about section 1366.
Yes, well, apart from the fact that it's not a point in my learned friend's scant argument and wasn't part of his grounds, but it is before us, and I can see that it troubles the court. I think the answer to that is simply this. If my client's a deemed secure tenant under what I say is the proper construction of section 123(3), they are deemed for the purposes of Part 5. They take the tenancy, or they sit with the tenancy initially as a joint tenant, same way as Tong, then later as a sole tenant. If you destroy the tenancy on which my client is parasitic upon, as my learned friend puts it, you destroy with it my client's tenancy. He has a deemed secure tenancy, but for very limited purposes, for the purposes of Part 5. Without section 1366 constructed in the, I mean, assuming that the court's with my learned friend about his construction of that, there was quite some debate about exactly what that section means, and it is a bit of a horlicks in terms of a draft. It's difficult to understand it. I can see why Her Ladyship understood it in relation to the landlord, but that it doesn't quite fit as the land. It doesn't really make sense. I think probably Your Lordship's construction in relation to it being the family member is probably right. My learned friend's construction is probably right. So what we've got is we've got a family member who, under section 123(3) is validly required. That continues. What 1366 does is provides the opportunity for the actual secure tenant, not the deemed one, to assign that tenancy otherwise, and thereby retain full control of the process of what happens with their tenancy. I mean, subject to, of course, to all the conditions that are attached to an assignment.
So what you're saying is that it allows the incoming tenant to say, I'm not sharing with the family member of the outgoing.
It allows the incoming tenant to do that. It allows the outgoing tenant to say, I'm assigning this tenancy to somebody else. And the assignment of that tenancy is a full assignment of that tenancy, which would only, which could prevent the family member from continuing with the right to buy application. Could do.
Yeah, I follow.
I mean, I think that's, and I think it has to be like that, because otherwise, because one of the other things that my learned friend was dealing with was this business of what happens with the secure tenant in various different circumstances where they may somehow lose control of the situation because they've tried to validly, or they have validly shared their right to buy. This is another way in which the actual secure tenant retains control of the situation, because they can assign that tenancy without leaving an assigned tenancy, which then the family member has the right to buy on, whether the assigned with the assigned tenant, whether the assigned tenant wants that or not. I think that's got to be what it's there for. I mean, it's a badly drafted
so
provision.
if you've got a succession, either by death or by divorce, and somebody comes in, the idea is that they shouldn't be, to use the vernacular, lumbered with somebody who's already there with a right to buy.
I think that's right.
Save in circumstances where they would be bound in any event by that.
Yes. It's I mean, it's a badly drafted provision. It's not clear. It's confusing. But I think that's got to be its purpose, and I think any other purpose doesn't really make any sense in that regard. I mean,
It'd be a lot simpler if Parliament, if the draftsman has simply said, in such circumstances, the secured tenancy comes to an end. Deemed secure tenancy comes to an end.
That would have been a lot simpler.
Yeah.
But I mean, it is the housing acts are notoriously difficult to deal with, because the drafting upon drafting and consolidation and from quite some time ago, and things being preserved. But I think that's got to be right. The difficulty with deeming the secure tenant at any later stage other than by the notice is, of course, the words of the statute itself, which is very clear that it's by such notice that it's deemed, and it's deemed for the purposes of Part 5, and it's not deemed for the purposes of Part 4. So all the other problems to do with what happens if a tenant does this or does that or does the other are all solved by the local authority or the landlord bringing possession proceedings, because there isn't a real secure tenant. There's only a deemed one for Part 5.
Yeah.
I hope that's helpful.
Do you wish to reply, Mr. Calzavira? No. Well, thank you both very much. Very economical argument. We will reserve our judgment. You'll get a draft in the usual way, subject to an embargo, which means what it says. We would hope that in the light of the draft judgment, you will be able to agree an order disposing of the appeal and send in any typographical corrections that there are to be made. And in due course, the judgment will be handed down remotely, so there will be no need for further attempts.
My lord, would the court like that passage from the encyclopedia?
Yes, I think that would be
Very
helpful.
helpful,
Please,
thank
you would send it
I'm
in.
sorry you didn't already have it.
Thank you.
May I have the right email address for me?
The wrong person, I think.
Or is it the other? Is it